The Supreme Court of Canada sits at the very top of Canada's judicial system. It has the power to uphold or reverse the rulings of all lower courts. It can also overturn laws of Parliament. For 150 years, the rulings from the Supreme Court have changed the course of history. Its judicial independence and ability to adapt over the years have ensured its survival, and its continued ability to evolve is key to its future. Jean-Simon Schoenholtz was a tour guide and law clerk at the Supreme Court and now argues cases before the court.
I think that's going to be the fundamental challenge for the court, is to continue providing guidance with a steady hand, but on issues and facts and a society that's evolving at a rapid pace.
That rapid pace includes key issues the court is expected to face in the coming years. Janice Tibbetts is a professor at Carleton University and spent years covering the Supreme Court as a journalist.
Some of the ones now that I see coming up, and something that's been a hot topic for about a decade now, is environmental rights. And the Supreme Court's just turning its attention to, environmental rights, I think, in a very big way. I think technology, too, is a really big issue that they're struggling with, especially in criminal investigations and the use of text messages, for example. There have been a few decisions on that.
The biggest technological challenge the court is expected to face soon may be on artificial intelligence. Adam Dodek is a law professor at the University of Ottawa.
How should it use AI? How should judges use AI? How should it deal with lawyers who want to use AI? But then also the legal issues surrounding AI will come to the court for adjudication. The second area that I think will be a growth area is Section 35, which is the Aboriginal rights provision of the Constitution. It's outside the Charter, but I think it's equally impactful as the Charter. And when we talk about reconciliation and now issues of Indigenous self-governance, that I think is going to be a real big issue for the Supreme Court in the next 10 and 20 years.
The other issue many court watchers believe may affect the future of the court itself is Section 33 of the Charter of Rights and Freedoms, known as the Notwithstanding Clause. At times referred to as the override, it allows federal or provincial legislatures to pass a law for a 5-year period to override personal freedoms. Bill 21, the Quebec secularism law to prohibit the wearing of religious symbols, is being contested under the Charter. Political science professor Robert Schertzer.
The case is really about the constitutional law, about whether courts can declare a law unconstitutional even if a government has applied Section 33 to its legislation. That says we are going to pass this, whether we think it's constitutional or not, it shall pass under Section 33 of our Charter. Essentially, governments are saying we recognize it may infringe Charter rights, but we're going to pass it anyways. The Supreme Court decision that's currently being just contested, and we should get a decision within the next 12 months, is about whether a court can still hear that case and rule and declare that the action is unconstitutional.
Professor Emeritus and Charter expert Jamie Cameron.
There's a more recent scholarship that argues that the court's role is not over just because the override has been used, and that courts can play a role in interpreting and reviewing legislation that is subject to the override. The caveat is that they cannot invalidate the legislation as being unconstitutional, but who's to say that they can't interpret the legislation and make declarations, for instance, that would tell members of the public, of the Canadian community, whether the legislature has acted constitutionally or not.
McGill University political science professor Christopher Manfredi.
There's a growing scholarly debate about the Notwithstanding Clause. I think there are more scholars writing in favor of it than there used to be, but at the same time, there are a number of scholars who are skeptical of the Notwithstanding Clause, trying to find new ways to give the courts even more power over how the notwithstanding clause is implemented.
Since the Charter was adopted in 1982, criminal defendants have used the Charter and the rights it protects to challenge lower court decisions. Former Supreme Court Justice and criminal law expert Michael Moldaver says he thinks changes may need to be made to the criminal code and the criminal trial process to help guide justices and reduce lengthy waits.
I think perhaps in our exuberance to protect the rights of accused persons and minority groups, and I have no problem with that, but we've given over the process to process, and in the process we've all but lost sight of truth and justice. And I think it's time maybe that we take a hard look, sort of try and recalibrate, put the system more in balance where the rights of the accused, which are vitally important, and I don't suggest they're not, are in many feel that they're out of balance with the rights of the public to be protected and live in a safe environment, and that we've gone too far one way, and that we need to bring back some balance and proportionality into the criminal justice system.
Next year, the court will move into temporary headquarters near Parliament Hill as the current building is modernized. And judges are set to hear cases outside of Ottawa, giving Canadians a chance to see the court in action.
What we've seen over the last, over the last 150 years, the Supreme Court has become a much more central element of Canadians' political institutions. From an institution that barely had 5 judges, who many of whom didn't want to live in Ottawa, and whose first courthouse was in Old Stables, if I'm not mistaken, into a court in which the Chief Justice is, the current Chief Justice is undertaking an incredible PR blitz to promote the court. We shouldn't be mythologizing the court. These are 9 individuals who have their own political views. They do their best to decide cases.
Legal historian and law professor Constance Backhouse.
I would hope that our premiers and our prime ministers in the future, if they deeply disagree with a decision of the court, that they would say in public, well, I disagree with the court, but that's their job, I have mine. We will respect that decision and we will implement it. Stop, full stop. And I think that is the highway that we should try to take between the institutions as we move forward. You can disagree, but you need to be respectful.
Former Prime Minister Kim Campbell.
Rule of law is so important. It is the foundation of our democracy, more important even than elections. The rule of law that applies to everybody. I think we have a very deep obligation to be custodians and preservers of the law, because our future depends on preserving the rule of law. And if you don't think that's the case, look south of the border at the moment.
For 150 years, the Supreme Court of Canada has evolved from becoming the highest court of the land in 1949 to interpreting the Charter of Rights and Freedoms adopted in 1982. In the coming years, the court will be called upon to answer questions on a number of issues that will shape the legal landscape across the nation for years to come.